My name is Leili Fatehi, and I represent Friends of the Mississippi River, a leading citizen-based organization that works to protect and enhance the Mississippi River and its watershed. Thank you for the opportunity today to speak against House File 766 as amended. And the problem with this bill is that it encourages the very early use of an adversarial process when it's not only unnecessary but also bad policy. The bill essentially encourages people to preventatively challenge the MPCA over regulatory decisions that they haven't yet made and requirements that they haven't yet imposed and may very well not impose in the future. And the reason that they may not impose those requirements is that the draft listing is itself a mechanism for triggering collaboration between the agency and the regulated party about the specific circumstances of the water quality issue in question so that they can work together and come up with some sort of mutually agreeable outcome. There's no obligation that's imposed by a draft impairment listing, and even final classification as impaired doesn't necessarily bring with it requirements for particular TMDLs, RAPs, or any other specific cleanup requirements. So the bill really undermines mechanisms that are in place to encourage the agency to engage with regulated entities to develop cleanup plans that work for both parties. And in fact, it's not unusual for a body of water that appears on a draft list to be removed before the final list is published because the agency and the regulated entity have been able to resolve the issue. So, one reason that it's bad policy to move into this adversarial process very early is that it undermines this ethos of collaboration between the agency and the regulated party, which I've heard, quite a lot in this committee that, people want the agency to spend more time working with them rather than against them. This makes that much more difficult. Second, encouraging contested case hearings early in the process also comes with a very expensive price tag for both the challenging party and the MPCA. It makes it an upfront cost for the agency and for the regulated entity to pay for a challenge to a decision that is as yet unmade, rather than making it an expense that's only paid if and when a regulatory decision is made following considerable formal and informal opportunities for regulated entities and the agencies to agree as to an outcome. So rather than going to lawyers, this money could be better and more efficiently spent by the agency if it were used in the course of those deliberations and reaching a final designation, or used to provide technical assistance, for example, to get the water cleaned up so that it can be removed from the draft list and never put on the final list to begin with. Third, as a related matter, I worry that this bill may create a significant chilling effect on the MPCA carrying out its required responsibilities under both state law and under the Clean Water Act. If the agency fears that it'll have to go through lengthy and expensive adversarial proceedings each and every time it preliminarily considers whether a body of water should be considered impaired. And were this to be the case, my concern is that it would undermine the public transparency and accountability of the agency's process, because the agency would be more inclined to do its deliberation about what might be an impaired water behind closed doors rather than through a published impaired list. And then finally, I want to point out that there's...
Quickly, please, okay?
This is the last point.
Yep.
There's nothing in the status quo that prevents a regulated entity from petitioning for a contested case hearing on a draft impairment listing right now without this law. Even without the authorization, that right already exists under the Administrative Procedures Act. And if I can figure that out, I'm pretty sure the lawyers for a lot of these regulated entities do. I think the reason that people don't do it is because I don't know why it is assumed that an ALJ is more likely to produce a favorable outcome for a regulated entity than a negotiated process with the MPCA. Certainly the CGM has availed themselves amply of contested case hearings and been disappointed at the outcome pretty consistently. So I think this bill risks worsening the relative bargaining power of regulated entities. Thank you.
Thank you, Ms. Fatehi.